Good evening to all and a warm welcome to everyone. FACEMI, Families Alliance on Mental Illness, founded by Dr. Nirmala Srinivasan, which advocates for the wellness of the persons with mental illness, whom we call as loved ones, and for their rights with both central and state government. Expert guidance and latest rules and regulations are imparted to family members actively through our monthly webinars and the vibrant WhatsApp group. Inclusive family is a salient feature of our group, and we're deeply rooted in our family ethos. We have 4 zonal groups: Shakti from Kolkata, Maitri from Bangalore, Shanti from Delhi, and FACEMI from Mumbai. I now request Dr. Nirmala Srinivasan to introduce the topic and say a few words.
There is some audio problem, Saraswati. Hello?
Yeah, we can hear you, Nirmala ma'am.
Okay. Thanks, Saraswati. Thank you very much. Welcome, Dr. Vishwesh and all our special guests. We have a couple of guests who are not exactly from the affected families. We are joined by students of the Center for Policy and Law, M.S. Ramaiah College of Law, Bangalore, group of institutions. There are a couple of more people from one or two people, if I guess the names correctly, they are from some law firms. So we are very happy to have a wide, diverse group of people here. And then, of course, the focus being the providing solutions to families who are looking for this important challenge of identifying a responsible guardian for the persons with mental illness in their own affected families. As you all see, today's topic is interesting, no doubt, but it's also little too baffling to look at. That, as you see from the title, spells out a cocktail of guardianship options never seen before. We didn't know such a cocktail, at least as family members, many of us don't know such a cocktail exists currently. These options, particularly at a time, very strangely, the law itself has mandated persons with mental illness not to have guardians. They can choose or not to choose a guardian. The right to choose, right to choice, right to live free legal capacity is very much granted. However, at the same time, there are these 4 options shown here are legal provisions, and our expert speakers today will help us take through this and analyze best of the options possible. So most of us are familiar with these options, namely the will, the private trust. Some of us at least know nominated representative and limited guardian. But not many would have thought of these as choices for PMIs, guardianship, and choices to be taken seriously and, if possible, exercised by next of kin when required. This exercise is mainly today's webinar. We try to analyze, the expert, Dr. Vishwesh, tries to analyze the merits and demerits of each of these independent arrangements that are possible and identify the best, quotes within quotes if possible, identify the best option that would not have been possible. He is trying to do it, and such an approach, combining all this, analyzing it, taking the best out of it, filtering through the process, what is the best? When you say best, whose interest it is the best? Does it serve the interest of the family carers? Does it serve the interest of the affected person? Does it abide by the laws of the land? Whose interests are we talking about? These are the very interesting questions that comes about. And this would not have been possible, my friends, but for FACEMI's rights-based solutions to challenges faced by families. We look at rights-based solutions, not just medical solutions or not just psychosocial solutions, but right-based solutions. And it's also the most important thing, apart from our own approaches, it wouldn't have been possible for us, but for a dedicated advocate like Vishwesh. He's have been dedicated to this cause, not just today or yesterday, for the last 2 decades, having served in various expert committees, legal expert committees of the state government himself. We are very lucky to have you, Dr. Vishwesh, today. Let's all give him a big clap. Those of you who can hear me, give him a big hand, please. And with that, I hand over it back to Saraswati. Thank you, Saraswati.
Thank you so much, Dr. Nirmala. I would like to...
Thank you, madam.
Welcome. Yes.
Just a minute.
Saraswati, please go on.
Yeah. To introduce our speaker, Advocate Dr. Vishwesh Sekhar. He's a PhD in law from Symbiosis International University, Pune. His
Something
thesis
is not okay in the audio. Can others hear your audio?
Ma'am, I can hear Saraswati.
Okay, then
We can hear Saraswati.
Okay. Please continue, Saraswati.
Yeah. His thesis completed in 2020 was on reasonable accommodation and accessibility as human rights for the physically disabled person in India. He's a graduate of the National School of India, University, Bangalore. He completed his BA LLB from here in 1997 and enrolled as an advocate before the Karnataka State Bar Council in August of the same year. He completed his LLM in human rights after nearly 16 years of practice from Symbiosis Law School, Pune. Now an advocate with 27 years experience, he is a senior advocate and a legal member of the local level committee for guardianship for Bangalore Urban, both under the National Trust Act 1999 and the Rights of Persons with Disability Act 2016. Dr. Vishwesh Sekhar was a counsel for the petitioner in the PIL, which resulted in the RPD rules for the Karnataka, and argued the matter for priority in COVID vaccination for the disabled throughout the state. He has widely published and articles in lots of journals, and he is also co-authored reports on employment rights of persons with disability and a systematic analysis of the UN Convention on the Rights of Persons with Disability. He was the only lawyer in the 16-member team of NGO representation from India who attended the 22nd section of the CRPD committee at the United Nations Geneva in August-September 2019. He's closely associated with the Karnataka Parents Association for Citizens with Intellectual and Development Disability and is co-opted member in their governing council. He was invited and attended as a subject matter the first national consultation on disabilities legislation organized by the Council for Social Development, Hyderabad. Since then, he has attended several conferences and consultations as a subject expert on disabilities. He is also the resource person for institutions like Nimhans. He has his office in Jayanagar and predominantly practices disability law and focuses on civil matters. I'll share you his details of his mobile number and I'll put it on the chat. Welcome, Dr. Vishwesh Sekhar. It's all yours right now.
Thank you so much. Now, can I start?
Yes, sir. You can go ahead, please.
Okay, thank you. Welcome to all of you. It's been a great privilege to address nearly 45 participants who are here today. Now, I'll start with where we have to go when we talk about persons with mental illnesses. Now, persons with mental illnesses have been for ages put into the basket of persons with unsound mind, idiots, hysterics, not worldly wise, and a whole lot of politically incorrect, socially incorrect, legally incorrect terms. Now, first we have to understand what a PMI is. A PMI, according to the Mental Health Act, is a person who suffers from a mental illness. Mental illness has been defined in the Mental Health Care Act in Section 2S as follows. 2S defines mental illness as a substantial disorder of thinking, mood, perception, orientation or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life, mental conditions associated with the abuse of alcohol or drugs, but does not include mental retardation. So this is what mental illness is. And a person with a mental disability or to qualify as a person with a mental disability under the Rights of Persons with Disabilities Act is when a person has a mental illness. Now, the difference between the Mental Health Care Act and the RPD Act has to be made out here itself. There are similarities and there are differences. The first similarity is that both the acts are to make sure that the UNCRPD is implemented in right earnest. But the difference is the Mental Health Care Act does not give a charter of rights as wide as the RPD. It does give rights. The Mental Health Care Act does give rights, but it is not as wide as the RPD Act. The RPD Act gives legal capacity as an individual right. That is a very important aspect that we have to immediately notice before we go on with the discussion. Legal capacity as a right is guaranteed under the RPD Act. But if you look at in the Mental Health Care Act, the rights given to persons with mental disability or mental illness are few in number and are restricted to the mental health care aspect of things. So, now if we go to the UNCRPD, see, the UNCRPD is a convention of 2006, which came into effect in 2008 and is the basis of both these acts. Now, in this act, that is the Rights of Persons with Disabilities Act and the convention, Article 1 and the Rights of Persons with Disabilities Act, Section 2, defines a person with disability in 2S as persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in the interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. This is a person with disability. Now, what is special about a PMI when it comes to disability? What is the unique feature that we have to look into when the disabled person is a PMI? The most important factor, according to me, is the lack of legal capacity. Most jurisdictions allow persons with mental illnesses to inherit property, but they do not give a person with mental illness capacity to contract. It is like giving a person a vehicle which he might get by inheritance, but not allowing him to drive because a driving license is denied. This is a broad example I can give you so that it makes it simpler for you. How a person gets property world over in all jurisdictions is by contract. He purchases property through contract because he has the freedom to contract in most jurisdictions. And second way of getting property is by inheritance. The Indian law as it stands today does not prohibit inheritance by a person with mental illness, but it very strictly regulates the capacity to contract of a person with mental illness. So, it is virtually impossible for a person with mental illness to acquire property through contract because according to the relevant section of the Contract Act, all contracts made by a mentally ill person or, as the word used, mentally unsound or of unsound mind, a person of unsound mind, is a void contract. Now, there have been lots of protests. Even the UN has recognized, the CRPD committee has recognized that terms like unsound mind, idiot, lunatic, all these terms have to be erased from the law books. But as it stands now, the capacity to contract of a person with so-called sound mind is a nullity. So, a person with mental illness cannot acquire property through contract. This is why guardianship is required. This is the second aspect I want to make clear here. Now, when we come to guardianship, for a person with mental illness, this is required to give him legal capacity. Now, look at the provisions for legal capacity we have in the Acts. Legal capacity is there in section 13 of the RPDA, Rights of Persons with Disabilities Act. But before that, I should quote that mental behavior is a disability under the Rights of Persons with Disabilities Act. Therefore, we have to go back to the Rights of Persons with Disability Act to look at what the provisions for guardianship are under that act. Entry 3 to Schedule 1 of the schedule to the RPDA, which lists out the disabilities covered under the act. Those are 21 in number. Entry 3 reads mental behavior and extracts the definition of mental illness from the Mental Health Care Act. This condition is classified as a disability. This condition immediately takes away the capacity to contract, therefore to acquire property and to hold property. And therefore, a guardian is required. Now, what is the provision as far as legal capacity is concerned? Before we come to that, we also have to see whether unsound mind is directly involved with the concept of capacity. Now, all mental illnesses are not unsound mind and vice versa. There might be, for example, somebody with bipolar disorder, bipolar affective disorder, who without a mood swing can take a legally binding decision if he is minus the mood swing. So, the medical condition may not affect his capacity to take a decision and is not such a barrier as to be called a mental illness when he is not suffering from a mood swing. This is what I would loosely call a lucid interval, which is again a concept that has been full of controversy. Let us not go into that right now. I will come into that a little later. Now, let us look at an example now. The concept of now, we will look at the case of X, who has made a will, leaving her properties and effects to Y, a PMI. The present position in law allows Y to inherit the property. But subsequent to the inheritance, the person with PMI cannot deal with the property as he or she wishes, because all subsequent contracts made by the PMI are invalid in law as void contracts because of unsoundness of mind. This is the crux of the matter. Therefore, we need some material, some legal method or methodology to grant to persons with mental illness, PMIs, a capacity to overcome what the law has taken away through friction. This is what is required. How is this? This is done through the mechanism of guardianship. When we talk about guardianship, there are two things we have to look into. One is substituted decision making. The other is supported decision making. Substituted decision making is when the person with mental illness is substituted by another, that is a guardian, as it stands today, who takes all the decisions on behalf of the person with mental illness without consulting him. That is a substituted decision. The decision is substituted by the guardian instead of the person with mental illness. The second aspect is a coopted, or I would say, a decision making which is in consultation with the person with mental illness. This is the second type of decision making that is anticipated or looked into. We will come back to the provisions of the Persons with Disabilities Act to find out which of these is accommodated in the Act. But before that, we have to go into legal capacity. Just give me a second while I run through the provisions regarding legal capacity. Legal capacity is in Article 12. I'm sorry, Article 12. Article 12, which says equal recognition before the law of the CRPD, in the CRPD. That is Article 12, which states very clearly that persons with disabilities, including PMIs, have the right to recognition everywhere as persons before the law. Number one. Then the second clause is very important, which states that the state shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. The third clause says appropriate measures shall be taken to ensure and to provide access to persons with disabilities with the support they may require in exercising their legal capacity. This is where guardianship comes in. They have been given some mechanism to provide access as a supporting mechanism to exercise their legal capacity. Because as I told you earlier, you have a capacity to inherit, but do you have the capacity to enjoy that right? No, you don't. So through guardianship, what is being done is a support mechanism is being provided for you to enjoy the right of what you have inherited. Or if you are allowed to contract during lucid intervals, then the fruit of that contract or of what you have purchased or what you have sold. So, the fourth clause of this Article 12 is also very important and reads as follows. State parties shall ensure that they shall take all measures relate to the exercise of legal capacity, provide for effective and appropriate safeguards to prevent abuse in accordance with international human rights law. Such safeguards shall ensure that measures relating to the exercise of legal capacity, respect of rights, and preference of the person are free of conflict of interest and undue influence, are proportional and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review by competent, independent, and impartial authority or judicial body. This is a provision that has been engrafted into the RPD Act when we talk about guardianship under the RPD Act, Section 14. I shall discuss that in detail in some time. Now, excuse me. Section 13 of the RPDA Act deals specifically with legal capacity and is talking about inheritance of property, both movable and movable, control of financial affairs, and access to bank loans, mortgages, and other sources of financial credit. Clause 2 of the section reads, the appropriate government shall ensure that the persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life and have the equal recognition everywhere as any other person before the law. That is taken from the article of the UNCRPD. Now the section goes on, and basically the protections granted in the article of the UNCRPD are engrafted in this section. Now, if you return to the Mental Health Care Act after looking at these two provisions in conjunction, now one thing we have to see is that this act has also been brought to ensure that the UNCRPD is implemented in our country. So, but the Mental Health Care Act is more focused on healthcare of PMIs rather than give them a charter of rights. Now, if I continue with the Mental Health Care Act, I would like to point out to Section 5(1)(c), which deals with, among other things, deals with advanced directives. A person can have a nominated representative through a advance directive or have a nominated representative through Section 14, which is, in the case of a minor, Section 15. So these are the provisions for nominated representative. Now, if you look at the powers of a nominated representative, this is where I come to the first part of our talk today. Whether guardianship through nominated representative is one of the choices that are really viable, whether it is comparable to guardianship under the RPDA Act, and whether it is comparable to testamentary guardianship, is something I shall come to. But we shall first look at nominated representative. Nominated representatives are confined to privileges and perks or rights that the person with mental illness has under the Mental Health Care Act. It is not a wider gamut of rights that the nominated representative can ensure for the person with mental illness, simply because Section 14 and 15 make it very clear that only those rights that are guaranteed under the Act can be got through a nominated representative. Section 17 of the Act makes it very clear when it comes to the functions of a nominated representative that a nominated representative can only secure those rights that are given under the Mental Health Care Act. So, therefore, rights like, for example, right to confidentiality, right to the kind of treatment he wants or doesn't want, these kind of things more focused on the mental health care aspect rather than the whole gamut of rights as to property and everything else. This is one thing we have to notice at the outset when we talk about the right of a nominated representative under the Mental Health Care Act being in a position to actually bring forth the entire rights of a person with mental illness in terms of his property. This is the entire gamut of rights with relation to property cannot be brought out by a person who is a nominated representative, is my submission. Now the next thing is that we have to look at is, so a nominated representative, let us look at we should also ensure that a nominated representative is there. It is not that a nominated representative does not have any role to play at all. When for the benefit of the person with mental illness, as far as his treatment and other thing goes, I think a nominated representative under the Act plays a very pivotal role. But when it comes to the broader gamut, no, a nominated representative is not the choice I would exercise. But a nominated representative along with a guardian is required, is my submission, as I will elaborate a little in the coming this thing. Now, while laws recognize the legal status, that is the capacity to hold rights of persons with mental health problems, they do not recognize their legal agents. That is the capacity to act. This is the crux of the matter where the slip between the cup and the lip arises. The slip between the cup and the lip is capacity is given, but enjoyment of rights is not allowed because of mental illness. A person with mental illness needs a guardian to actually exercise the rights which he has got to enjoy property. We have talked about nominated representatives and guardians. I will move on to testamentary guardianship now. Testamentary guardianship is or was a very popular method of appointing a guardian for a PMI. A person who had a PMI as a family member would normally leave a will saying, after my demise, X or Y shall be the guardian of my son or daughter or other family member, son or daughter who is a PMI. And the person so named, if it is a valid will and it is properly probated, would take on the shoes of the guardian and act as the guardian of the PMI. Now, what is the problem in this approach? First problem we have to address is that the minute anything regarding a PMI is mentioned in the will, every property that is in the schedule of the will is so-called, is unfortunately or fortunately tainted by the attitudinal barrier of people against mental illness. This attitudinal barrier is wrong, it's bad, but it is a fact which we have to face. The tainting of the entire will, when as soon as a person with mental illness is seen, becomes a problem. And you should also look at another important aspect, which is Section 28 of the Guardians and Wards Act. Section 28 of the Guardians and Wards Act is another reason why I would not prefer a testamentary guardian to be appointed. Not only because the mention of a person with mental illness in the will would make it very difficult for the executor of the will to do the other things that are mentioned in the will, but because of Section 28. Section 28 of the Guardians and Wards Act 1890. Section 28 of the Guardians and Wards Act 1890 reads like this: where the guardian has been appointed by a will or other instrument, his power to mortgage or charge or transfer by sale, gift, exchange, or otherwise immovable property belonging to his ward is subject to any restrictions which may be imposed by the instrument. So far, so good. The instrument here is the will. Unless under this act he has been declared guardian by the court, which may, by due declaration, permit him by an order in writing, notwithstanding the restriction, to dispose of any immovable property specified in the order in a manner permitted by the order. So a testamentary guardian can at some point of time always move the court under Section 28 against the testator's will or the testator's desire and get property transferred, say sold or mortgaged or otherwise dealt with through a court order. This is a possibility that the law has opened up, and it is not without some fear that I will look at it when a testamentary guardian is appointed. In the future, considering that the testator is dead, what stops a testamentary guardian from moving the court under Section 28 to actually go against the wishes of the testator is something that immediately makes me alert to the fact that such testamentary guardianship is fraught with danger. This is one aspect we have to keep in mind. Now, next is appointment of guardian through a trust. This is safer than a testamentary guardianship. A trust, as you all know, is a private trust. I'm not talking about public trusts. I'm talking about private trusts where a PMI is involved. The family can get together and form a trust. One of them can be the author, and the members can make necessary provisions for the upkeep of the PMI and other aspects, and also appoint a guardian. One of them can be the guardian of the PMI. Now, why is it safer or a better alternative than a testamentary guardian is because the Trust Act has provisions in which the beneficiary of the trust can seek the enforcement of the trust. A guardian appointed under the trust can, on behalf of the PMI, ask for enforcement of the terms of the trust and ensure that the welfare of the PMI is met. There are sections in the Trust Act which there is in fact a separate chapter in the Trust Act, which I will tell you right away, which tell you what are the rights and liabilities of a beneficiary. This is in Chapter 6 of the Indian Trust Act 1882, and a guardian can move the court and ensure that the rights of the PMI are met in toto whenever required. Finally, we come to guardianship under the RPDA. According to me, as it stands now, as the law stands now, having seen what dangers are there in testamentary guardianship and what dangers are there in trust. Trust also, there are dangers in the sense that the trust may not really deliver, or it may be fraught with other problems. And the money may not, or the benefit may not actually flow to the real beneficiary, and it has to be got through litigation. So trust also in that way is a slightly dangerous instrument. The safest, in my opinion, right now, as the law stands, in my opinion, is guardianship provided under Section 14 of the RPD Act. I will tell you why it is both in the benefit of the PMI and also safer in the sense that the interests of the PMI are met at all times. Section 14, firstly, why we are left and I have come to Section 14 last is for two reasons. First reason is I think it is the most optimum solution now. Secondly, because the section itself begins, notwithstanding anything contained in any other law for the time being in force, on and from the date of commencement of this Act, that is the RPDA, all guardians have been made limited guardians. All guardians are limited guardians from the date the RPDA came into force, whether they have been appointed by court, whether they have been appointed by trust, whatever be the mode of appointment, they are all limited guardians now. This to a large extent helps a PMI because it is not complete substituted decision making. Now, next, the section itself provides that a guardianship or a limited guardian shall be appointed to take only legally binding decisions on his behalf and in consultation with such person, that is the PMI, in such manner as may be prescribed by the state government. Now, the state government has enacted Rule 6 of the Karnataka Persons with Disabilities Act rules, and various other states have similar rules, which is a large rule and covers most of the important things that one would look forward to ensure that guardianship is safe for the person with mental illness. I will discuss that in a few minutes. Now the choice is given to a court. You can either apply to a court or to the designated authority for guardianship under Section 14 of the RPDA Act. Rights of Persons with Disability Act. Any person who suffers from mental illness is covered under RPDA. So you can apply under the RPDA. The RPDA has local level committees which advise the DC as to whether guardianship can be given in a particular case. What happens in these meetings is very simple. Once the application is filed, the PMI, the guardian, both are called. There is a committee consisting of a medical member, a legal member, a NGO member, and the district disability welfare officer, who is the ex officio secretary or chairman, depending on the state rules, who advise the DC as to whether guardianship can be granted in a particular case. So, limited guardianship is granted under this section. It is not complete guardianship, it is not plenary guardianship like under the National Trust Act. There is a difference between limited guardianship here and guardianship under the National Trust Act. That is a discussion for another day. But please note that it is not plenary guardianship, but is only a limited guardianship. Now, and limited guardianship is also defined in the section itself. For the purposes of this subsection, it says in the explanation, limited guardianship means a system of joint decision which operates on mutual understanding and trust between the guardian and the person with disability, which shall be limited to a specific and for a specific decision and situation, and shall operate in accordance with the will of the person with disability. So the limited guardianship is, in a way, very, very beneficial to the person with mental illness if the person with mental illness appreciates what he wants. Is there any question?
No, I think they unmuted themselves by mistake.
You can continue, sir. You can continue.
Yes, yes. And it says, on and from the date of commencement of this act, every guardian appointed under the provision of any other law for timing in force for a person with disability shall be deemed to function as a limited guardian. So you see, this provision, section 14, is a very benevolent provision. It does not look at plenary guardianship or substituted decision making, but rather limited guardianship, where the person with disability is given a say in matters involving him. So when it comes to enjoyment of rights of property, I think this say is very important. Gives a play in the joints, where a person with disability has a say in what he wants to do with the property or he does not want to do with the property. Now, I have to also quickly point out to Rule 6 to you. Rule 6 of the Karnataka rules. All states have rules for guardianship. I am looking at Rule 6 of the Karnataka rules. It is a very elaborate rule and runs to around, I think, 17 sub-rules in Rule 6 itself. It gives you a broad outline of how to apply for guardianship, who is capable of applying for guardianship, where guardianship will be granted and how it will not be granted, and other details. It is Rule 6 of the Karnataka rules. I do not want to read out the whole rules. But unfortunately, here again, after making a provision like this, it has been made clear that a person of unsound mind, that expression has crept in again. A person of unsound mind shall not be a guardian. It is very unfortunate that provision providing for guardianship, which otherwise has some positive aspects as far as PMIs are concerned, has suddenly used the term unsound mind again. I do not want to read the whole rule out because it runs to, as I told you, 18 sub-rules. But basically, the documents required for limited guardianship under the Rights of Persons with Disabilities Act have to be filed before the local level committee, which meets once in 3 months, at least once in 3 months. These documents are the application form as appended to the Act, the disability certificate and UDID of the person with disability, Aadhaar card of the person with disability and the proposed guardian, consent letter from the proposed guardian, which is part of the application, 2 sets of photograph of the person with disability with the person with the proposed guardian together, a statement of movable and immovable property of the person with disability for which guardianship is sought. So this will give you a list of properties about which you want to give the PMI a choice to decide on. His capacity to hold the property and to enjoy it. This list is submitted to the committee which will decide to give you guardianship, and then you can, as a limited guardian, taking the PMI into consideration, take decisions about the property as you may deem fit. Of course, you have to report this to the committee every 6 months. But if it is for the benefit of the person with disability, then the committee will not have any objections. Then the other document required is medical fitness certificate issued by a doctor with KMC seal, family tree, income proof of the proposed guardian, and NOC from other siblings and eligible guardians, and a police verification. These are the documents required that have to be submitted. There is a hearing of the committee which can recommend to the DC, and the certificate is usually issued within 3 weeks.
Mental health illness.
Yes, I think I have finished what I had to say. Does anybody have any questions? We can take questions now.
Okay. I request Sindhuda to take over and moderate the questions, please. Sindhuja?
I'm sorry, I could not unmute myself for a second. I have a couple of questions in the chat box, sir. I'll read them out to you if you could
Yes,
answer them.
Yes,
Is guardianship same like receivership?
Guardianship and receivership are different.
Could you just elaborate in a couple of sentences, sir?
Receivership is under the Guardian and Wards Act. That is a different kind of guardianship where it's for a minor. It is not for a person with disability. That is the fundamental difference.
Okay. Okay, sir. So going on to the next question, what is the government initiative to take care of the persons with schizophrenia after their parents are dead, are gone?
I think Madam Nirmala would be in a better position to answer.
Yes, I think this is not a legal question as such.
What?
Yes, sir. The next. Yes, sir. I'll go on to the next one. I think this can be answered later, as you said. The next question is regarding. It says there is a family trust which was made by the mother before her death, and
Yes.
the trustees can take action and does not include the PMI as a stakeholder. Do we need to amend the family trust? There is no will.
If the members are still trustees, I think the trust deed can be amended. There is no problem. If it is within the same family, the trust deed can be amended. I don't see any hurdle.
Okay.
It can be
So
amended.
the trust deed can be amended?
Yes.
Okay. Even if there is no will which stipulates
No,
any other occasion.
the will is, does the will create the trust?
That is not there in the question. This was asked by Dr. Mridula Seth. Dr. Mridula Seth, if you could unmute yourself and ask the question.
Does the
Is there any
will
other
provide for the creation of the trust?
Yeah, there is no will, and the trust was created 8 years back.
Okay.
The mother not having confidence in her son being able to take decisions, especially related to finances. So the
Okay.
trustees were appointed. I'm one of the trustees,
Mm.
and we did not include PMI as a stakeholder. So now that after
You can
listening,
include the PMI as a beneficiary.
yeah, he is a beneficiary.
Yes.
So is it, I mean, is
You
it the
can
same?
amend the trust deed. In the absence of a will, you can amend the trust deed. There is no problem in amending the trust deed.
But is there a need to have because it's a very complicated process to
It
amend
is. It is.
the family trust?
Yes, it is.
Okay, thank you.
But you can amend it. That's what I'm saying.
Okay, thank you.
Sir, PMI himself can appoint the guardian if he wants.
No, sir. He cannot. Because PMI is the person with disability.
Mhm.
PMI
going on.
himself cannot.
Yeah. I'll read the questions out of the chat box first. If anybody has a question, I would request them to kindly write it in the chat box. Or then after all the questions are done in the chat box, if there is somebody else who's willing to, who still needs to ask, then maybe if we have time, we'll go into that. Right now, I'm reading out the questions from the chat box. I request people to put their questions in the chat box. Okay, this will reduce the amount of confusion. Otherwise, if people unmute themselves and start asking questions, there could be an overlap. Thank you. This says, there's a question from Aneet that says, do these rules apply to all states, including Maharashtra? But you were talking about the Karnataka.
Every state has its own rules, madam, but by and large, the rules are similar. I can send across a copy of the Maharashtra rules. I have a copy of the Maharashtra rules.
Oh, that will be wonderful, sir. Thank you. The next question from
after the webinar, you just send me the email address of the gentleman or lady who wants it. I can send across the rules. Maharashtra.
Okay, sir. Okay, sir.
There
Thank you
might
so
be
much.
by and large, they are similar.
You could share it with Saraswati, sir. I think she, being the zonal leader over there in Bombay,
All right.
could be approached.
The
I think that would be a better
RPD
idea.
rules,
Yes.
right?
Yes, sir. Yes, sir.
Okay.
Okay, sir. Thank
Just
you.
send me an email after this webinar.
Yes, sir. I'll do that.
You have to be sent to.
I'll do that, sir. Yes, sir. Thank you.
Send the Maharashtra rules.
Okay. So the next question is, anyone apply for the guardianship through the National Trust website link? He also gives the nationaltrust.gov.in link here.
The National Trust is for persons with intellectual and developmental disabilities only.
It does not include PMIs.
CP and intellectual and developmental disabilities, autism.
Okay.
PMI is under entry 3 of Schedule 1 of the RPWD Act. Mental behavior, and the entry continues with the entry mental illness, which has been taken from the Mental Health Care Act, but does not include alcohol and drug abuse.
I hope it clarifies the question from Mr. Sudhir.
So please don't go to the Trust Act because your application will be rejected.
Sindhuja, sorry to interrupt.
It depends on your disability certificate.
There were a lot of questions which we had collated before.
Yes.
Would you like to start with those also first?
Okay.
Also, I have a point here.
Yes, please.
To the speaker, there was a question which two, three questions I think Mr. Bajrang asked you. He asked a very pertinent question, which was probably not responded to in the way I expected. He asked a question whether the PMI can choose a guardian.
See, he
And
cannot.
probably the response from
It
Dr.
is
Vishwesh was the PMI cannot choose a guardian.
no. His question was whether he can apply for guardianship himself. He can definitely
Was
choose
that
a
the
guardian.
question?
He can definitely choose a guardian. He cannot apply for guardianship himself.
Yeah, that was
He can
not. Yeah,
definitely choose a guardian. In fact, the PMI
and he
is
can
asked.
definitely go without a guardian also, right?
In fact, the PMI is asked in the interview with the local level committee whether he would like the person as a guardian, why he has come to the meeting, and all these questions are asked. He is consulted, and only then is the guardian appointed.
Yes.
But
So,
PMI cannot.
guardian can be appointed by the committee with the help of the PMI.
The interview process is that both are interviewed.
Mhm.
PMI cannot say, I will apply for guardianship. The application has to be signed by both, and it has to be initiated by the person who wants to become guardian.
Yeah, and should be appointed by the committee only.
After taking into consideration what the PMI says.
Yes, it is right, but it can be appointed by the committee only with the consideration of
The committee will recommend to the DC. The DC will issue the certificate.
Mhm.
Dr.
Okay, does that-
Vishwesh, I have a couple of information to share since you're talking about Karnataka.
Yeah.
Sindhuja, can I just share it? Because later on,
Yes, sir,
I may.
please go on. Please go on, ma'am.
As a member of the Karnataka has recently set up a high-level committee in 2023.
Mm-hmm.
And I'm a member of the high-level guardianship committee of Karnataka to amend certain rules.
Mm-hmm.
In this amendment, one of the things is very relevant to the question raised here by somebody who said that the brother or sister is an RFS institution. So one of the amendments we have asked for is those PMIs who don't have any family trust or else, who are in institutions, the institutions can become guardians, and for that
Yes.
new rules have been drafted.
That rule is there. That rule is there in the Karnataka rule itself. An organization can apply on behalf of.
But they did not. That was not. It was not clear where they go. They don't go to the committee, but they go to special courts. Institutions go to institutional guardianship. That is one suggestion.
They can come to the committee.
No, the committee will forward these to the special courts. That's what we have suggested. Because many institutions, we have no idea which institutions have licenses or not. So many questions came up in the meeting. So it was decided by the director disability who chaired the meeting. It was on August 8th this year. It was decided the institutional guardianship can be, it's not mandatory. For example, we can't force an institution to become a guardian. But if they have to become a guardian, the committee will forward the application to special courts. It's not yet, this is not yet notified, I'm just sharing. The other important thing from family's point of view, the other important thing, Dr. Vishwesh, what you had said, that the guardians can also be changed. One of the things we had asked some of us is, you had very clearly pointed out about nominated representative. Some of us have asked in that meeting whether the nominated representative and the limited guardian can be one and the same person. What is your opinion as a lawyer? Because we have not yet got through that. The rules have not yet been notified, or we don't have what is happening to the rules. But is it possible? Because it's very difficult.
Yes, it is possible. Yes, it is possible. There is, as far as I see in my legal opinion, there is no hurdle for a person who is a nominated representative to also fill in the shoes as a legal guardian, as a limited guardian. There is nothing, there is no hindrance at all. One person can be both.
Which is more encompassing, the nominated representative or the limited guardian?
The nominated representative plays a role only in so far as the rights guaranteed under the Mental Health Care Act are concerned. So that is one part of it. Those are decisions regarding mental health care primarily. But when it comes to property and other things, you have to have a guardian who is appointed under the RPD Act. As a limited guardian, which I explained to you, who will consult the person with mental illness and take a decision. So both are required. And there is no harm for one person being both. Because they have been
But we
appointed
have to
under
approach
different acts.
But there are two different mechanisms of
There are two different
appointing.
mechanisms, but serving the best interest of the PMI. So in my legal opinion, there is absolutely no harm, or it is not illegal if one person becomes both, because it is in the broader
This is
interest of the
exactly why
PMI.
we had asked for this. Yes. That's the reason, and I'm sure this is going to come through. But this is one of the concerns that a PMI cannot have many people to interact with. Yes, Sanjita, please continue. This is all about Karnataka. Many lot more things are there in Karnataka rules, guardianship rules, which are going to get amended. But as and when it's notified, we'll have another. Sanjita, please take over and go forward. Hello, Sindhuja?
Hello, Sindhuja, are you around?
Saraswati, why don't
No, Sindhuja is there.
Hello, I'm sorry. I got muted automatically. So I didn't realize that. I'm sorry. 1 minute.
Yeah, continue, Sindhuja. Thank you.
Yes, ma'am. Yes, so the one of the questions that was earlier shared, Dr. Vishwesh, was that can a husband and wife both make a will together for different real estates and other property? I think what this means is that some of the property is in the name of the wife, some is in the name of the husband, some are jointly owned. What about so what will and what is a demat account? They want clarification on that. Sir?
Sorry, I got muted.
Yes.
First, talk about joint will.
Okay, sir.
Joint will is a will where two or more persons make a joint will to the effect that each has properly executed a will as regards his own property. Is that clear? Regarding my
sir, can you please elaborate?
Regarding my property, I have said it is usually between spouses. Regarding my property, I have said this will go to ABC. And regarding her property, she will also say it goes to ABC. This is a joint will. Or they marry each other. This is a joint will.
Okay.
Beneficiary can be the executor also of the will.
It is usually not recommended. Usually not recommended. He can be, but it is usually not recommended. There is no legal bar on it, but usually it is not recommended.
Any reason why so?
The reason is because when there might be some hurdles, saying the executor has not been impartial or has tried to play the fool or something like that.
Understood. Thank you.
There is no legal bar, but encouraged.
The other question is about the demat account, sir. What is a demat account?
A demat account is an account where you can have nominations like your normal account. So there is no special provision regarding leaving it in the will. You can have nominations like you have for the normal accounts. And once a nomination is filed, it's over. The nomination will take precedence over everything else, and it will be given to the nominee. You can have
so
up
that
to
can also be just mentioned in
the bank. No separate provision for there. It is not any different from a savings bank account.
But a nominee,
yes,
nominee need not be the final beneficiary of the amounts or the.
That is true. That is true.
Could you
But
kindly say
in demat, nomination is the final. It cannot be changed. It is like decision is there of the court. I heard.
That decision I am not aware of, sir.
I have read only that nominee is a trustee. The obligation to redistribute whatever benefits are there.
Yes, that was the recent judgment which was reported in the press. But I have not read that judgment completely, so I don't know.
Okay, moving on to the next question, sir. What is mirror wills and reciprocal wills?
1 second, madam. I will just start in a minute.
Yes, sir.
A mirror will is two wills which are created spouses that names each other as the main beneficiary. Each a backup plan, so both partners are involved. For example, in a common accident. But it is different from joint will, which is one document which serves the need of two people.
So here are two wills.
Yeah, it's mirroring. In one will, I will leave it to my wife, and my wife will leave it to me. That is a mirror will. A joint will is that we both leave one single will.
And this is a reciprocal will, sir.
A reciprocal will is the same as a mutual will, a mirror will.
They're the same. Mirror will and reciprocal are.
Yes.
Okay.
Sir, in a joint will, does it, sir, one question about joint wills is in that joint will apply only to properties or assets owned jointly, or could they also, leave their individual property, state their individual property?
They can leave their individual properties also. That is why a joint will is discouraged. Because if one person changes, because everyone has a right to change their will till the time of their death. If one changes, then there will be problem. Joint will is not encouraged.
But what about, can the joint will then only talk about, but then again, if there is a joint property, that means,
joint
let's say husband
will is a very good idea. If it is
right, only in respect of joint properties, and then they can also, then it can concurrently there can be separate wills in respect of each of the individuals.
Yes.
Right. So there could be a joint will and an individual will, both operating concurrently or existing,
or a joint will and codicils. An addendum to a will without revoking original will.
Okay, so that would be a
or
codicil.
Changing some conditions in the original will without revoking.
The codicil also needs to be vetted. Same advocate who has made the.
It need not be the same advocate, not be the same witnesses, but it holds as a separate document.
No, but
it's better you go to the advocate.
Okay, thank you.
Because he would understand the will better.
But in joint property, 50% is there, can be presumed, and it can be given to.
Yes, it can be given. It depends on the will of the testator.
So separate can be prepared for joint will of 50% share.
It all depends on the wish of the testator. So the testator can do anything as long as it is self-property. He give it 9, give any person at all. He can do whatever he wants as long as it is his own property.
Recommended
He can do with the 50% share only, which he.
No, it is a will. It is a will, and if it is property, it is entirely the wish of the testator, which changed till the time he dies.
Name is there in the property, then 50% is presumed that each 50.
Yes, but if you break that rule and you write a will against it, also it will be challenged. That's all.
Okay. Yes, going on to the next question, sir. If,
Yes,
if the PMI gets divorced in the future, can the spouse claim alimony from the inherited property that he has
No.
inherited from his parent?
No.
No. Okay.
No.
You stated that
Once the
Excuse-
divorce is done, it is over.
Okay. So once the PMI gets divorced, the spouse cannot claim alimony from the inherited property.
The tie of husband and wife or spouses is finished. So
Okay.
if that happens before the devolution of the property, then there is no right as a spouse to the ancestral property or any other property subject to the settlement in the matrimonial suit.
Okay. Going on to the next question, is a will required for finance if the finances are in either or mode? What about immovable property? If it is in joint name, is it required? And is probating a will mandatory?
Probating a will is not mandatory, madam. Probating a will is not mandatory, but if it is immovable property, you have to get it probated. Probate is required only in certain cities in India. But if immovable property is involved in Bangalore, they are now asking for a probate for change of casa and other purposes.
And so the question also says, is a will required for finances in either or survivor mode?
That depends on the person, madam. If he wants to leave a will, it is well and good. If he doesn't want to leave a will, the bank will take care of it.
Okay.
In
The next
in
question.
Navi Mumbai, probate is required for the immovable property, sir. It is compulsory.
I am not sure, sir. I am not sure about Navi Mumbai. I will find out and let you.
Sindhita, kindly moderate the discussions, please.
Yes, ma'am. The thing is that there is a when the sir is giving an explanation, and if there are questions, they are not writing it in the chat box. They want to ask themselves at that particular moment. Yes, that is why the question is going on. Yes. So let me read out the other questions also. If there are questions from the members which relate to one of the answers that is already given, you can go back to that. I would request people to wait till all the questions that have already been given in the chat box or to us earlier, once they are answered. If you have similar questions, kindly, they will also be answered. And if you have other additional questions, you can ask at the end of the whole session. Okay, going to the next question. Should we mention about the illness in the will? Will this lead to complications in the future? Complications with respect to sale of property if the property is owned?
Unfortunately, yes.
We have to mention.
Yes, it is best that it is left unmentioned, or if possible, a certificate of disability which says disability is less than 40% is a possibility to get over this stigma that is unfair, but it exists.
Okay. So the next question is,
can you please repeat a little more, elaborate this, please, Dr. Vishwesh?
The you mentioned PMI in a will, there is a problem. That is very clear. So the way out can be having a medical UDID saying less than 40%, which is not benchmark, or not mentioning it at all. Mentioning it in a codicil also will not make any sense, because when a will is examined, the codicil is also examined. So this is my short answer to the question. There would be problems if the PMI is mentioned.
But if PMI doctor psychiatrist, but if the PMI gets a psychiatrist,
excuse me, please wait.
Your questions are being asked. Just wait, sir.
Yes, please wait.
All the questions which you had given earlier are there in the list, and they would be asking one by one. So just please wait, sir.
If the PMI wants to sell the property, the best way to do it is through appointment of guardian through the RPD Act. That is the safest way to go. That's the easiest way to go.
Okay, thank you.
Because the decision as to selling of the property is taken in consultation with the PMI, as per the requirement of section of the explanation to section 14. guardianship explanation clearly says in consultation with the PMI or person with disability.
But PMI
Okay.
can make the will with the certificate of the psychiatrist, his psychiatrist doctor. Can it be done if he make the will
Can
of
be
the
done if there is no challenge later, then the lucid interval question will come. If the doctor certifies that it's a lucid interval, then you have something to back you, but you cannot stop a challenge.
I hope that answers your question,
challenge.
sir. I get
Sorry?
that. Yeah, no, I'll go on to the next question, sir.
Yes, please.
This says legal stand of nomination when a will exists and when it does not exist.
See, nomination is something is like an instruction to the bank. So it is best that both be consistent. What is there in the will and what you have said in the nomination. And as somebody else pointed out, a nominee is merely the trustee of the amounts. So that is the difference between nomination and what is stated.
So if there is no will, what is the legal standing on the nomination?
Nomination is the only thing left. So the bank will follow the nomination instructions and give the money to the nominees or nominee.
Okay. Registered will, unregistered, what is the stand?
A registered will always prevails over an unregistered will. If there are two wills which are contested, a registered will prevail over an unregistered will.
Okay.
A registered will is easier to probate.
Okay.
So it is always better to register a will. And registration of a will does not give it finality because another registered will can be made until the last minute before the person's death. Any number of wills can be made. Any number of wills can be registered.
So any later will supersedes
the last
will
will always prevail. The last registered will always prevail over any unregistered will.
What's the difference between a registered will and a probated will?
A probated will is a will for which you have got a probate under the Indian Succession Act.
Excuse me, there are lots of questions that we have already got from people earlier, and I would like to finish asking those questions before people ask questions now. Kindly wait. Some of your questions might be answered. Some of those questions might actually be your questions also. So please wait. I go to the next question, sir. Can I name a nominative representative chosen by my son, PMI, in my will? Can I name a nominated representative chosen by my son, who's a PMI, in my will?
For what purpose? I don't see any restriction.
Okay. Okay. So what the next question is, what is probate and how different is it from being registered?
I think that question I just
asked us our answer.
Yes. I think that is why I request people to kindly wait. See if your question is also part of the questions that we already have with us. The next question, sir, it says, legal stand on notarizing a will. Why is it necessary?
Notarizing a will is absolutely useless. If it is registered, nobody will notarize. Notarizing a will is completely unnecessary. It's just as good as an unregistered will.
Oh, so what is required is registering the will.
What is required is registering the will. Notarizing the will is completely unnecessary step.
Okay. The next question is, who can be the witness?
As long as you have two witnesses, two independent witnesses, and everything else is in order, the will is valid, even if it is unregistered. Only where the problem comes when there is a contest between a registered will and unregistered will, where the registered will prevail. And registered will does not mean is not the equivalent of a notarized will. A notarized will is simply a will executed in front of a notary, and notary will not come as a witness. So notarizing a will has no particular legal significance of any sort.
Okay. The next question is, Please, could you please wait for us to finish with the questions that we already have? Kindly, sir. The next question is, who can be the witness to the will and what is their role during execution of the will?
Any person can be witness to the will, as provided that it is advisable that they are not beneficiaries. Any person who has legal capacity can be witness to the will.
And what is their role during the execution of the will, sir?
The role is not during execution of the will. Their role comes up when the will is put in court. They can certify to whether the will was executed in front of them.
Okay.
So they can give evidence as to the will was actually made.
Okay.
In
That
Where
is
they are
probate
not
also they
allowed,
should be required. In probate also they will be required, or only in contest we witness.
During probate, a witness is not required, sir, unless there is a contest. During probate proceedings, witnesses are not called usually, unless there is a contest in the probate.
Okay.
if
Going on to
the
the
witness is not
please
alive,
just-
hello, if the witness is not alive, then what case? In that case,
In that case, we cannot do anything, sir. We cannot bring a dead man back. But the problem, that is why while writing a will, we should always choose younger witnesses.
okay, thank you.
Okay.
Typical of Dr. Vishwesh.
Okay, so the next question is, I do not have want to do a will of real estate, but want to do a will of fixed deposits in various banks. What can we do?
If it is a property, leave a will.
Excuse me, sir?
You can leave a will only your removable property, and your removable property will go according to interstate succession.
Okay. So a will can be made for the movable properties also.
Yes.
Yes.
The
The
rest
next.
of them will be covered by if you had no will.
Okay. The
What?
next question is, I want to write a will to my brother who has mental illness. How do I go about doing it?
First step is consult a lawyer.
I think he's consulting you right now, sir.
I am not here to give legal advice, madam. I should tell everybody
No,
that this
I
is a
think that is
webinar for
I
information.
exactly, sir. I think
This shall
that is
not
where
be
the
treated as
understanding.
consultation.
Yes, that's understanding. I think is that is where the difference is. Okay, I would request the person who gave this question to seek legal opinion
Yes.
and go to a lawyer straight. Yeah. The next question is, what are the challenges for execution of the will if the patient is the only surviving heir?
I don't see any challenges. It would be easier, no?
There'll
Nobody's
be no
going to-
contest.
There'll be no contest. What is the
Yes.
provision? What is the problem? I don't understand.
Okay, if this person who gave this question has any other questions, clarifications, they can ask at the end of the question answer session. If we settle private trust for the disabled, how is it established for the benefit of the person?
This also you have to contact a lawyer.
Contact a lawyer.
Explain your situation. Talk to the person with mental illness. Come talk to a family member. Talk to other people who you can trust. Because the trust, as the word itself says, depends on trust.
Okay.
So that
Going
has
on
to
to the
be
next
decided
question.
with your lawyer.
Yes, sir.
Sindhuja, I think the next question is already asked.
Before my PM. Yes, okay, yes. Will she did not leave a will or nominate a guardian. Yes, okay. Being the only child and nominee, I think this is a continuation of the same question, 17 and 18. Before my PM. Yes. So,
Yes.
okay, this question I think needs to be read out. Yes, 1 minute. Before my yes, PMI's mother has who expired last year has created a family trust. I am one of trusts. She did not leave a will or nominate a guardian. Being the only child and nominee, he has inherited all the wealth, including the FDs. Now he is spending money recklessly. The PMI, sir.
Okay.
he is spending money recklessly and not interested in transferring money to the trust, which was intended to look after his needs. Wants the house to be transferred to his name and not the trust, which was intended his mother after his needs death. Do how to ensure his money is safe and stop him from spending indiscreetly.
Well, one way to stop him is to claim that he is a PMI and he cannot contract.
Okay.
Stop him from selling the property. That can be done.
They can contest that.
Otherwise, the trustee should take action under the Trust Act and say that ask for accounts. There are remedies under the Trust Act which the trustee can explore. Under the Trust Act.
Okay.
There are remedies where the trustee can approach the court, ask for accounts and clear the mess in the trust. There are remedies in the Trust Act.
Okay,
Yes.
so they need to look into that and consult a lawyer for that.
Yes.
The next question is, my son.
There is a related question, Sindra, about the.
1 minute, ma'am. I'll just have a look. There are 2 more questions only. I'll just have a look.
Oh.
No, ma'am. There is no question which is related to that, but I've not seen the chat box yet. Go ahead, ma'am.
No, you were saying that stop the property by being sold by the PMI. I have a question. Can't the PMI question the validity of the trust under the Act, under the RPWD Act, which you said from henceforth the guardianship is only this Act and nothing else?
But
so the trust,
guardian has to be appointed.
Invalid, yes.
A guardian has to be appointed first.
There is no guardian here, ma'am.
There is no guardian here.
No, I got it, but I'm going ahead of this. I'm asking, can't the PMI, there is no guardian, but the PMI, let us say, can choose a limited guardian and say the trustees are no longer valid, the trusteeship is not valid, and on account of the RPWD Act, the Indian Trust Act or the private trust under which it has been created is rendered invalid. Can he do that legally?
You will have a very good moot point. It is a very good area. It could be a decision that I.
As of now,
it is possible.
That is the gray area is between the private trust and the limited guardian.
It is possible. Your line of argument is very possible.
Okay, thank you. Thank you, Sindra.
Yes, the next question is, my son is schizophrenic and I can't appoint my daughter as guardian since she is an American citizen. My relatives are not willing to take the role of a guardian. I'm confused. I am also not willing to appoint any other person outside of our relatives as the guardian. What is the way out? I'm in the process of making a will.
She can appoint a testamentary guardian and hope for the best. It's the only advice I can give her now.
Okay.
And in any case, you cannot appoint a guardian against the will of the PMI.
I think here the willingness is, or the unwillingness is on the part of the relatives, not of the PMI, sir.
If the relatives are unwilling, then the mother has to leave a testamentary guardian.
What would that be? Could you just elaborate that, sir?
Either she can become the guardian now.
Yes, sir.
And after her, leave a testamentary guardian and hope for the best.
Who would be the testamentary guardian, sir?
That is up to her. She can name anybody.
Yeah, okay. Because she is not able to.
It is her will.
She's American not able to, citizen can be made testamentary guardian. American citizen.
American citizen, if it comes to court, they will say, see, the point in appointing a guardian is to take care of the welfare of a person with mental illness or person with disability. A person who is not in the country cannot do this, cannot discharge functions of a guardian. So normally, as a rule, we do not allow foreigners to become guardians or non-resident Indians to become guardians.
So, sir, going ahead, if there is nobody who can be appointed as a guardian, what does the person do?
In what sense are you saying?
I'm saying like the lady is asking here that she is in the process of making a will. Her son has schizophrenia and her daughter cannot be a guardian. No
Yes.
other person is in their relative circle is ready to be a guardian. She does not want to look beyond the family to look for a guardian. So what is the way out? What does she do?
Unfortunately, she's stuck in no man's land as far as Indian law is concerned. We do not have the state taking care of people like without guardians. It's either he goes on with life without a guardian, or some guardian is appointed with his consent.
With his consent.
Yeah.
Since
Consent.
Sir,
All
if
consent.
sir, excuse me, sir, if that person is admitted in a rehab center or somewhere, can they become guardians then? If there are no parents
A rehab center for what, madam?
for their future life or whatever, like long stay homes or something like that.
If it
they are
is rehab
shifted there.
for alcohol or drugs, they are not considered disabled. But if it is other rehab centers, the center can probably take over as guardian.
Okay, sir. Thank you.
That is subject to the amendments that madam was talking about.
Court can appoint guardian if
Yes.
suppose nobody is guardian.
Court can appoint, but somebody has to move the court.
I have a, Siddhika, excuse me, can I
Please
share
go
an
ahead, ma'am.
observation here?
Yes, ma'am.
Yes,
Yes, ma'am.
according to Karnataka State Disability Rules, Director of Social Welfare Board becomes the guardian of the orphans. We have 2-3 cases which have come up to the district collector, and he has said, yes.
Which district? Which district, madam?
Karnataka, Bangalore urban. One retired from coffee board or some board for his pension, and he has no guardian to monitor. To the bank is not releasing his pension. So now the director of the social welfare board has been made a guardian. So it's already there in Karnataka state rules, Dr. Vishwesh.
I see.
Yeah, the director of the social welfare board becomes. We have also suggested to the government a couple of NGOs together jointly, along with the director of social board, becomes a kind of trusteeship. One of the director. So we don't know whether that will come through with our suggested amendments.
Okay.
Yeah.
Okay. So going on to the next question. If a person suffering from mental illness makes a will, the MBBS doctor certificate is sufficient for the will, or a psychiatrist certificate is required for making the will in Navi Mumbai?
I do not know the law in Navi Mumbai, number one, but generally speaking,
PMI can he make?
Generally speaking, a PMI during lucid intervals can make a will.
Okay. Okay, but what is the requirement in Karnataka, sir, for a PMI to make a will? He's talking about the certificate from a MBBS doctor or a psychiatrist for the disability. Is there a requirement? Hello? Hello? Sir, you are muted. Dr. Vishwesh, you're muted.
I'm sorry.
Yes, I'm sorry. I think it automatically mutes people. Yeah.
Since he's a PMI, the will be challenged on the ground that he was a PMI.
Okay.
To rebut the fact that the will is valid because he's a PMI, a certificate from a doctor saying that it was made during a lucid interval would be of some help.
Okay, and that needs to be a psychiatrist?
No, that can be any doctor.
Any medical doctor, yes.
Yes, that can be only used for rebutting the presumption that he was of unsound mind.
Okay, during the making of the will.
During the time he made the will.
Okay. I hope that answers the person's question, but there is if there is any change in the rules regarding Navi Mumbai, we are not very sure, sir. Okay, is it here again the question is about Navi Mumbai, but anyway, is it compulsory to probate a will in Navi Mumbai? What is the procedure and cost to it? I think this
The
also needs to
procedure
be
is that procedure is an application under the Indian Succession Act. Under the relevant section of the Indian Succession Act,
Indian Succession Act.
it has to be filed before the City Civil and Sessions Judge. It is the petitioners versus no respondent, and you annex a copy of the will and say, I am the executor, so I need to go ahead with what is stated in the will. The court will grant probate putting a paper advertisement, and a probated can be executed as any other means of dealing with.
If in will there is no executor, only the beneficiary, then
That is a badly drafted will, sir. That is a badly drafted will. Then the beneficiaries have to fight for themselves and make sure that they get what they want with mutual understanding.
Okay. So there are lots of questions in the chat.
I'll just.
Yeah. I think we have answered the question till
Anit of Maharashtra. You'll have to go
yeah,
to
Venkatesh Iyer. Venkatesh Iyer, I have you. Okay.
You had earlier more ahead, Sindhuja.
Yeah.
Up to Anit, we asked that including Maharashtra. You'll have to ask from Mr. Sudhir Kumar.
From Mr. Sudhir Kumar.
Yeah.
Anit asked and one more question, so I'm a little.
Yes, please. Please go.
Yes. Guardianship. This is a question from Mr. Sadashiv Sivaswamy. Guardianship, however qualified, is it essential? My son just won't accept appointment of a guardian. He has bipolar. Can't a trust replace a guardian, whatever limitations are, if there is no immovable property?
First of all, if you want guardianship, the consultation with the PMI is absolutely essential. So going through the statutory route is ruled out.
Okay.
A trust, maybe you trust and appoint a guardian under trust. It is a private. As far as the statutory route is concerned, it's all ruled out because a person with mental illness will be asked whether he agrees for the appointment of that particular guardian or not.
His consent is absolutely necessary there.
Yes, he will be asked. And depending on his capacity to answer, a decision will be taken by the panel.
So a trust can replace a guardian in these circumstances?
Yes, because a trust is a private arrangement.
Okay.
But again, as Madam pointed out, it's the trust may be overridden by what is stated in the statute because it says notwithstanding anything contained in any. And any other guardian will be a limited guardian. That is provided in the Act.
Okay. Dr. Vishwesh, if you know, sorry, nothing, sorry.
If the trust itself states that it is governed by Disability Act, which is that notwithstanding anything contained under any law, whatever is the testamentary guardian, it is not possible to make a provision. When you make a guardian under a testamentary will, that is the least difficult of all the alternatives.
It is the least difficult, sir, but as I pointed out, Section 38 is there. The guardian might later move the court to dispose of the property. The testator is dead. You must remember, in a testamentary guardianship, the testator is dead.
But in the trust, PMI can give consent. But PMI can give consent in the trust also that this guardian can be appointed. I give consent.
So here the question was mainly that the person is not willing to keep a guardian or act a guardian. That was the main question here. Okay. How can a guardian of a PMI transfer his or her guardianship to another member of the family?
Guardianship has to be applied again. For first time, it is granted for 5 years. Next
Yes.
time, when the up to 5 years. So if there is a change, you have to apply afresh.
Okay. Is a PMI allowed to contract a marriage?
That is a well settled but tricky area. Avoidable marriage is because many mental conditions are considered grounds for divorce, including bipolar.
Yes, sir. So, if a PMI enters a contract of marriage and it can be
Voidable.
contested by his
It's voidable.
guardian, it is voidable. Okay. Where a PMI himself does not have sound mind, how can a joint action can be taken with mutual consent?
Yeah. In a mutual consent divorce?
Not a divorce here. I think it is just generally saying that you're talking about guardians and the NR to take the consideration of the PMI also in consultation.
The committee would interview the person with mental illness and then take a call on whether the person with mental illness has the capacity to understand and give us the answer.
That's good.
It is not mere questioning and for the sake of questioning. There is a doctor also in the panel. So an evaluation is made as to how she understands.
Yes.
There is a doctor also in the panel.
Okay. So next question is, can bipolar PMI be a guardian for a severely affected PMI if the mood swings of the bipolar person is under control? Bipolar person might be a guardian for the person.
I don't think it will be possible. I don't think it's possible.
Can I just come to this?
Yes, please.
Unfortunately, the rule should be on mind.
Right. The thing is that my husband to be the guardian because there is other family who's ready to take responsibility for the severe PMI who have how do we do that because interest in care.
But to one of the guy wanting.
Okay.
Don't disclose your EDID card if you want to be the guardian.
Okay.
You have to also get a medical certificate from the doctor saying you're medically fit. How are you going to manage that?
Okay. But then that is the only family member. Then any other non-family member can become guardian?
Madam suggested, I think there is a rule now saying that the DC can himself be the guardian.
But that's only in Bangalore, sir. Any other city, the rules change.
Yeah, Maharashtra change of rules. Okay.
Not DC, not DC.
The
director
department,
Department
of
Social Welfare Disability.
Sorry.
Okay.
Social Welfare
Director of
Board.
the Social Welfare.
Welfare Board, yeah.
Sorry. Yeah.
Okay.
So it cannot be a non-family member.
No,
excuse me. Yeah.
A non-family member can be a guardian provided that you are in being a your EDID.
No. I mean, my husband himself is he's saying not. But what about a non-member? Like if I am the wife, I am not a family member of hers, then can I still be a guardian?
Other blood relatives or caregivers of the or prominent personality can be guardians. Blood relatives or caregivers.
Only blood relatives. Okay.
Can be.
Okay.
Other blood relatives or caregivers.
Acha, or caregivers. Okay.
Or caregivers can be guardians.
Okay. Got it. Thank you.
Okay, this says if he is allowed all the rights under the UN Convention and subsequent laws in the country, can a PMI marry? Mental illness is also is only a ground for divorce, not for marrying.
If UNCRP is enforced in full strength, madam, on 3rd of December, we'll have a party. But it does not happen that easily, no?
Yes.
The attitudinal barriers are very huge.
True.
But his illness is disclosed to the spouse that he is suffering.
Marriage.
Yes. Is there any difference in relationship of a person with mental retardation and mental illness?
Mental retardation is covered under National Trust Act only. The Mental Health Care Act clearly excludes mental retardation.
Okay.
So once you think of mental retardation, you can remove the Mental Health Care Act out of your purview and go to the National Trust. They are two separate things.
Okay.
Mental retardation, immediately go to National Trust.
Okay.
Mental come to Care Act, RPD.
RPD. The next question by Mr. Ganesh Vettel is, his son is 30 years old. I want to make a will. My concern, the whole property and financial decisions to be restricted to daughter. Nobody should cheat the beneficiary. In this case, how to a draft will?
That is, I should not be giving legal advice, madam. That is
legal
his
advice.
property.
Yes. This is to be talked to a
property.
lawyer separately.
Let him speak to a lawyer.
Yes. In limited guardianship, in disposal of property, if some siblings are hostile and don't consent for an NOC, what's the option?
NOC is required.
Is required. There is no option available.
Is required.
Okay. Mr. Prashant K. Bangalore says 20 of GNW Act mentions fiduciary. Can we include to have guardians make necessarily courses for this? Can we include family therapist or limited guardian? For example, to ensure regular sessions for the family. Currently, there are lots of with CAPRD due to social stigma.
That was slightly complicated for me. But
yes, I didn't understand the question. I'm sorry. The fiduciary, I didn't really understand what
I gather is it's part of it is from the Guardians of Act.
Yes, sir.
Hello. My just answer.
Yes.
So my
go
question
ahead,
is
sir.
just my question.
Yeah.
Small clarification. I to the lawyer. So he told me not mixed. Want to give and you also want to decision for your daughter. So the thing is there.
Basically, what give your property right to your daughter, what she does with it is not controlled.
I am giving to PMI, and for his act, I am appointing my daughter as a guardian, restricting the property.
In the will. See any problem?
He is telling that you one side you are giving freely property to your son.
No, appoint your daughter as the guardian in the will, and say property shall be taken care of on behalf of the PMI. No property goes to your only guardian.
Like for also I can make
anything is your own. You can do anything on your property.
Okay, thank you.
So coming back to the question on the guardians and what, sir?
Different statute, different ball game. It is a different guardianship thing. It is not for PMIs primarily.
No.
PMIs get their ship only at PW. So I don't know this fiduciary where it comes. I didn't understand the question. I'm sorry.
Actually, I could send it to you separately, sir. If you could read it yourself, I
Please,
think that
please.
will be better. I'll see if I can send it. So I'll send it to WhatsApp. I'll go on to the next question in just
Yes.
just 1 minute. I'll send this to Dr. Vishwesh because I don't think it should be left unanswered. I've just sent it by what I could take it later after with the rest of the questions here.
Definitely, definitely.
Yes, 1 minute. I've lost track of.
In without if anybody dies and there is daughter, then daughter release is required or not?
Sir,
For the release, daughter is required for the son.
Please repeat your question.
Suppose in state anybody is there. There is in state. One is daughter and one is son. And son to get off, then his daughter's release is required. Daughter is released.
Yes.
Is required. You know.
What do I want to do? Property.
Take it solely and praise no
objection. Given objection. He wants to. If he wants, if the rights in the property, she has to give his deed.
Bajrangji, sir, I really request you to please do not unmute yourself and ask the question because there are a lot of people who have put the questions on the chat box. Let us finish that and then we can come to you. I would really sincerely request you to please follow some, please.
Okay, going on to the next question. Thank you, Saraswati. By Mr. Rajiv Sikta. I am the elder brother, 70 years old, of my sister who is a PMI. She is aged 59. I am looking after her after her parents' demise. Is it mandatory that I register myself as a legal guardian?
Whether registering as a legal guardian is mandatory or not depends on whether she has property, tends to do with property. How would he dispose of the property registered as a guardian?
Okay. So for legal purposes, it is better to register himself.
For example, to operate her bank account.
Yes.
For example, he would require guardianship, no?
Yes. Okay. So then going on to the next question, if a PMI cannot appoint guardianship, then how would they? I think this question was answered by user Anit had asked the question herself. The next question, my brother is a president of Jyoti House of RFS. Can RFS be made a trustee under the RPWD Act?
A trust is a private arrangement. Please ask them to talk to a lawyer and
okay, sir.
Get it sorted out whether they want to put whoever they want.
Okay, they want to put an institution.
Wills and trusts are private arrangements. They have to speak to their respective lawyers and.
Okay. The next question is by Mr. Rakesh Kumar. Can you give an example for creating the trust and what factors need to be taken care? I think this also requires him to be talking to a lawyer, sir. It talks about taking care of how to form a trust. The next question is Mr. Tyagarajan. Government is introducing a bill allowing multiple nominations in the bank FDs. Can this be extended logically to appoint multiple guardians, as if one guardian dies, other will take over?
As of now, no.
No.
As of now, no. But if amendments are made about appointing several guardians, then there'll be a quarrel between guardians. How are you going to deal with that?
Yes. Okay. This is guardian number 1 and guardian number 2. That cannot be done right now.
Yes.
Okay. The next question by Mr. Abhijit Bhattacharya. Is there any age limit of a person with mental retardation before which guardianship can be appointed? Can a
retardation is under the Trust Act,
under
madam.
Trust Act.
It has to go to the National Trust through the
Can
National
a person
Trust.
with National Trust Act?
Yeah.
Okay. Can a person with mental illness open a bank account?
Through a guardian.
Through a guardian. Okay. Suresh, Mr. Suresh asks, can foreign national relative become a guardian for a
Sorry,
PMI who's an
Chandra, I
Indian
have to.
resident?
No.
Chandra, 1 minute, please.
Yes, yes, ma'am.
Regarding this bank account, I have a letter from RBI.
Yes, ma'am.
Dr. Vishwesh, I have a letter from RBI saying the 2018, I think the letter says that many banks are asking for PMIs to have guardians who open accounts or deal in financial transactions and various instruments. It should not be done. There is a letter, but unfortunately, the banks have not circulated it.
So as it stands now, I think a guardian is required, right?
Under what act?
Under the RPD
Under
Act.
what act?
RPD Act.
To have a bank account?
Yes, I think that is the position as it stands now, considering that the letter
Section
has not
13
been
of the
circulated.
Section 14 of the Act doesn't say that, Dr. Vishwesh. They have access to deal with property, interact and all that. And what basis can the bank ask for a guardian to operate an account? If it is a pension account, probably they can. But a normal SB account or a salary account, what is your view on that? Your take on that?
Legal capacity has been given. Yes, legal capacity has been given.
Only through guardians, madam.
No.
They themselves can operate. That's what ma'am is saying.
No, I'm saying, and this is happening.
Yes.
But there is a RBI letter which I'll give it to you, Dr. Vishwesh, if I get it.
Okay, please pass it on. Let me look at it and get back to you.
And the RBI is addressed to branch manager, branches or heads of various banks. This is public sector banks, not private banks.
If you are going to a bank branch and they interview the PMI, and if he is correct in telling the name and all and signs before the officer, then they will open the account. What is there? If he says the PMI and does not tell his name and he is behaving somewhat differently, then the question will come. You bring the guardian or something like that. Once the officer suspects that he is not in sound mind, then he will ask everything.
Yes,
if he says the name and correctly, address correctly, KYC correctly, and everything correctly before and signs also in the letter of introduction or something like that, then the officer will open the account. Where is the need for suspicion? But he may be suppressing the fact that he is PMI. That is different.
Is it necessary to disclose? That is also a question there.
Yeah. Because at the time of taking back the money, for a problem will come.
Okay.
Yeah.
The letter from RBI. The letter from RBI should, I think, set right these questions also.
Yeah. Once you deposit the money, bank will willingly take.
Giving it back, they will.
We are running out of time also.
Please go ahead with the question.
Yes, that's what I'm saying. We are running out of time also. This question, I think, was answered. But anyway, can foreign national relative be a guardian for a PMI who's an Indian resident? No. Okay.
Rules are there, but is there a legal prohibition against appointment of a foreign domiciled sister?
It was clarified that she is not present physically to take care of the person, then she cannot be a guardian, sir.
No. The point is there legal prohibition?
Is it prohibited by law, Dr. Vishwesh?
There is no prohibition, but practically it is not possible, no?
No. That is the thing.
Taking decisions on behalf of the person with disability in consultation with is rendered impossible when the person is not here.
Sir, in these days of electronic communication and all that, if there is no legal prohibition, and if a guardian's appointment through a testamentary will is the easiest of all procedures, why not adopt that procedure? Because a sister settled abroad, a foreign national, can communicate with the PMI electronically and operate on his behalf unless there is a legal prohibition.
Yeah, and I
There
think
is no express legal prohibition.
yeah, and today with banking being able to do it through the net, everything is possible.
So, Advocate Mr. Venkat,
There is no legal prohibition. There is no express legal prohibition.
Okay. The next question asks, does lucid interval or mental capacity, does it have to be certified by anybody?
That I think we discussed, no?
We had already discussed.
Yes.
It has to be by the committee. And guardian created by a will be restrained from abuse of his rights by a suitable enforceable provision in the will itself. It is clear that appointment of a guardian through a will is the least cumbersome. How do you stop a guardian from abusing his rights?
You cannot, because the testator will be dead.
Any suitable enforceable
That depends on how the
provisions in the will.
will is worded and
Yes,
what
exactly.
restrictions are there in the will.
That's what he's asking. Whether can enforceable provision in the will, can it be added to restrain the
Added
abuse?
when?
While making the will.
The will takes effect after the person dies. So while making the will, you have to be careful.
Yes. So make the suitable arrangement while writing the will itself. In the will.
Yes. In the will.
Okay. If a property is registered to the daughter of a PMI and she passes away, then do we proceed to transfer it back to the mother who is a
Why?
PMI? I don't understand. I myself am not very sure about this question. It says a property is registered to the daughter of the PMI, and if the PMI dies, then do we proceed to transfer it back to the mother?
I think if the daughter dies.
Yes, the PMI, the daughter dies, and the property should be given back to the PMI.
Yes.
Can it be transferred back?
I don't see any hurdle in not being transferred back. But to
Yes,
hold
sir.
that property, he needs a guardian. As I
Yes, sir.
told you.
That is the thing, because what has happened is that it was a gift to the daughter, and unfortunately the daughter has died. So now the mother being the PMI, like I mentioned, so we don't know whether we should do a transfer back to her, and what happens if interstate something happens to her? That is the concern.
Interstate Hindu, it will go according to Hindu law. Muslim, it will go according to Muslim law. So it's like that.
So it will go as per the Hindu law of whoever is the next successor. Yeah, okay. Got it. So we do go ahead with the process of giving it back to her name, registering it.
Yeah, you can go ahead.
Okay, okay. Thank you.
Can POA be given in Karnataka by a person with mental illness for sale of property in some other state?
A power of attorney is an instrument that requires complete full legal capacity.
So it can be given to the guardian in case of sale of property in some other state also, not in Karnataka?
Now there is a judgment of the Supreme Court saying sales through power of attorney is not valid.
Oh. There are so many O's.
There is some confusion regarding that. So you better consult a property lawyer before taking a decision on that.
Okay. Sir, in two state properties there, then the two guardian can be appointed, one in Rajasthan, one in Maharashtra, one in Karnataka. Yes. Three properties there then. Three guardian can be appointed.
Where is the provision for multiple guardians, sir?
There is no provision for multiple guardian.
No.
He had answered this question.
Okay, which was already answered, yes. If prenuptial agreement is entered between a PMI and a non-PMI, is a will advisable?
The voidable marriage,
it's a voidable. Again, he cannot enter into a contract.
The contract is a void contract.
Is it mandatory that only an allopathic doctor can be a witness to the will? Is it necessary for a doctor to be Witness
No,
to a
there
will?
is nothing.
There
Anybody
is
can be a
nothing.
witness as
Anybody
long
can
as he
be
has
a-
legal capacity.
Yeah.
Can a PMI challenge the trustees of his trust as not valid because they are substituted decision makers?
Oh, that is a tricky question. Who was the jurist who wants to know this?
I had asked you earlier, I put
Just
it
asked
here.
by Dr. Nirmala.
Because there are a lot of faith put in, misplaced faith, I think, put in trust. People, the trust is such a, it's a lot of families hold trust as a very sacred thing to
Sacred thing.
protect the interests.
Yes.
Whereas I agree with you 100%, Dr. Vishwesh, the trust is a myth. And limited guardian in any case, as the day in the meeting, the director disability said at least once in 5 years, we shall come into the picture to see if the guardian is doing a proper job or not. Whereas
Yes.
in the trust, it's nothing like that is there.
Nothing
It's
happens.
insulated. So that's why I had asked you at the beginning, but I wasn't sure whether I'll get a chance, so I'd put it here.
Section
So
60
the
says
trust,
right
in
to
fact, I
proper
think people
trustees.
should. Sorry, please.
Section 60 of the Trust Act is the right to proper trustees.
Yes.
So you can technically move the court under that section.
Very difficult, easily said.
It is not a viable solution. It's not. Going to court is not a viable solution for anybody.
Yes.
PMR or otherwise.
Correct.
Litigation is not viable anymore for anybody. Is my personal opinion.
It's neither a legally sound and not even socially viable. We don't find trustees more younger than PMIs.
That is true.
And then the trustees to come for a quarterly meeting itself is a very big thing. And so in spite of all that, family members have a lot of faith in the trust and not in limited guardian.
Maybe they are afraid to run around, fill in the forms, get a police clearance.
Bangalore Urban District Welfare Officers doing, until recently it was Devana, but now I think it's somebody else. I forget the name of the gentleman. They've already have about 13, 14 applications cleared by the collector. A few more are pending, and then it's not so bad as the people thought it was.
DWDO Bangalore Urban.
Bangalore Urban.
Krishna Kumar.
Bangalore Urban has a different, that is next to Nimhans in that small lane.
Yeah,
Bangalore Urban, they give
Krishna
the
Kumar.
forms, we have to fill it up.
It's Mr. Krishna Kumar, he says.
Pardon me?
Mr. Krishna Kumar.
Who?
Is the DWDO.
The DWDO.
Is he for District Welfare Officer for Bangalore Urban, is it?
Yes, yes.
Has he taken over from Jabuna? I don't know.
Yes, yes.
Okay.
Nearly
That,
4 5 months back.
With Sindhuja's permission, I'm taking the liberty of asking you, Dr. Vishwesh.
Yes.
You are not only been an well-known advocate within the courtroom, but also I met you more as a disability activist. And therefore, anything that is required for the Karnataka members of Maitri, especially those, most of us, 99% of Maitri members are residing in Bangalore. Is there a possibility of having a camp professionally? I mean, in the sense, we don't take your time for granted. Whatever is your professional charges for that is possible, that we do it. But is there, as a facilitator, can we hold a camp, getting the district collector and the maker for those families who want it?
100%. I think it is the need of the hour.
I think so. Then we should
Not
do
because,
it.
Not because you are paying me, but even otherwise.
We'll definitely pay you. I know you have done free service.
That is not the need of the hour.
I know. But I mean, not to belittle the services we have done, nothing like nowhere far from an advocate. Absolutely. When I met you as a disability activist, I couldn't even believe that an advocate could spare so much time and be dedicated to the cause and the individual. It's admirable. Please.
Thank you.
So
Thank
that
you so
is
much.
possible. If you can hold a
We
camp.
still
and
have we still have a couple of questions, ma'am. Can we just go
Please
through that
ahead,
first?
Go ahead.
Yes.
Can we not send it to him in the email?
There are just about 5-6 questions, Nirma.
There's just this is 5 or 6 questions left. It says my brother is has schizophrenia. I want to make a will, but there is no guardian. What are my options?
Consult a lawyer. Do it.
From your answer to a question, how a joint action with mutual consent is possible, I understand that a legal guardian has always to approach a panel to act on small or big decisions. Am I right? No.
The panel decides you're the guardian, then you just have to file a report every 6 months saying what you have done with the property. But whatever decision you take about the property should be in consultation with the PMI.
Yeah, that's all.
Okay. The next question is, can a PMI allowed under the law to give wakalat and fight against abuse of rights by a trustee? Again, the same similar question.
Right to have proper trustee is Section 60 of the Trusts Act.
Yes, so he can contest.
Can he give wakalat? There is provision, the old provision in the 1908 CPC saying suits by persons of unsound mind. That is also possible.
Okay. If a marriage is voided due to mental illness, is maintenance still payable by the PMI to the other? It's a void.
Once the marriage is over, there will be a settlement once and for all, usually. After that, the right to get maintenance on a regular basis ends.
Okay.
On
The next
divorce,
question.
the marriage comes to an end.
Okay, sir. The next question is by Mr. Gaurav. He says, I'm a high-functioning schizophrenia patient. I'm married with a daughter. Do I still need to appoint a guardian after my parents' death? Is making a trust for me essential?
He wants a trust for himself.
Yes. Is it necessary, or is it necessary to have a guardian after his parents' death?
Not necessary. Why? Why should he? If he doesn't want a guardian, why does he? If he's of his personal opinion that he doesn't need a guardian, why go through the rigmarole?
Okay. So it is only if he wants a guardian that he needs to appoint a
whether
guardian.
he needs a guardian. No.
Yes. Okay. So if he feels the need for a guardian, he can appoint one at a later date.
Yes, he can.
Okay. The next question, there are 3 beneficiaries in a single property and one of the beneficiaries is an executor of the will. Is it proper to appoint a beneficiary as an executor? I think you answered this earlier also.
I answered this.
Yes.
It's a tricky thing. It's normally discouraged.
Okay. How can the guardian of a PMI transfer his or her guardianship? Okay, this also you have answered, saying that they need to apply for the guardianship again. Yes. I have already registered a will. Should I make a separate will or a codicil appointing my daughter, who is an American citizen, as a guardian for her bipolar elder brother? Again, answered earlier. Full family trust or legal guardian, which is better for a PMI?
Family trust, no.
No.
Legal guardian, yes.
Is it better to enter arbitration arrangement with family therapist so as to have amicable conflict resolution and decision making? I did not understand this question, sir. If you can understand it, is it better to enter arbitration arrangement with a qualified family therapist so as to have amicable conflict resolution and decision making?
I think
is there a case pending in which arbitration is required?
Can a family therapist be involved in the arbitration?
No, arbitration, if it is a family settlement that's coming out of it, anybody can be the arbitrator. Elders can be arbitrators, family members can be arbitrators. But what is the nature of the dispute and all that we have to know, no?
I think the person feels that a qualified family therapist, would she or he be more suitable as an arbitrator?
If the end of the day the dispute revolves within a family,
yes, that is why
anybody can be
they're looking at
arbitrator.
as
Anybody can be man and arbitrator. I don't think there is any disqualification of a family therapist being an arbitrator.
Okay.
He's not a qualified arbitrator under the Arbitration Act, but he can arbitrate.
Okay. You had already mentioned this, that there is a one-time settlement if there is a marriage that is voided. What does that involve? The question says, what is a settlement in a void marriage for a PMI?
No, once the marriage is over, the divorce would have ended up with a settlement, right?
That is what he's asking. What is that settlement? I
That
didn't.
depends on what the court will give you, what the court will decide. If they decide it's a void marriage and let go of both the parties, then there is no settlement. But usually one of the parties will say, you put me through this for such a long time. I demand damages or demand alimony or demand something.
Yes.
Depends
So
on
that
what
needs
the
to be
court
settled.
decides.
That needs to be settled as per the court's decision.
As per the court's decision.
I have come to the end of these questions in the chat box.
Yes.
I think we've also run out of time completely. We've taken up extra time from you, sir.
Not a problem at all. Thank you. It was
Thank
a pleasure.
you. Thank you, sir. If there are any other questions or anything else that comes through, we can always
100%.
approach you. Thank you for that, sir.
100%.
So on this note,
I have to send you the Maharashtra rules.
Yes, sir. Yes, sir. That was again asked in the chat box. Yes, sir.
Madam, one small point.
Yes, please.
What is best, guardianship or trust?
Guardianship, sir, in my opinion.
Okay, sir. Okay, thank you.
In my
well organized program, sir. Madam,
Thank you,
well
sir.
organized program.
Thank you.
Thank you very much, sir.
Yeah. Thank you, Cynthia.
I think we'll close the meeting for today.
Thank you. Thank you.
Yeah. At the
Thank
end
you,
of
everybody, for a well-organized program.
Thank you. Thank you, sir. We would just like to formally propose a vote of thanks to you, sir. It has been a very informative talk, and also the fact that you were able to answer the questions that popped up in the middle of the whole question answer session. Thank you very much for being patient and listening to oft repeated questions also. So thank you very much for being here with us today and helping us understand the provisions and the legality of certain questions that were asked. Thank you very much, sir.
Thank you very much.
We would like to end the proceedings with the FACEMI pledge. Saraswati to kindly.
My personal thanks to you, Dr. Vishwesh.
Thank you, madam.
And
I've already taken the pledge.
Pardon, I'm
already taken the pledge.
I can't hear at all.
No, he's saying he's already taken the pledge. I said we'll finish with the pledge. He said he's already taken.
No,
so I
I'm
request
looking
Saraswati
forward to the camp, limited guardianship camp.
Yes, sir. Yes, that I would also look forward to. Saraswati, are you saying the pledge?
Yes. I'm just doing it. Just give me a second, please.
Yes. I request everybody to stay on mute. I will read out the pledge. I request you to kindly just follow it by yourself, but without unmuting yourself, please. Kindly stay muted. The FACEMI pledge. We, the members of Families Alliance on Mental Illness, FACEMI, pledge to support one another and other families in similar situations and use language which conveys love and respect towards each other and especially towards PMI. We shall strive to protect and promote the rights of PMI as enshrined in the laws of the land. On this day, we take this pledge to work towards the vision and mission of FACEMI. Thank you very much.
So people who had asked about where they could send the questions, I think somebody you could send it to us in the WhatsApp group which we have, and we could take it forward from there on.
Madam, you can forward it to me after you get it.
Yes.
Yes, sir. I think Saraswati, they should forward it to one of us because in the group it could get lost.
Okay.
So it should be sent individually. You could send it to me. My name is Sindhuja. I will write my number and my name in the chat box now. Any additional questions, kindly send it to me. I will forward it to the lawyer.
Sindhuja, madam, please forward it to me. I'll answer.
Yes, sir. Thank you so much.
Including the Maharashtra rules, I'll answer in one shot.
Okay, sir. Okay, sir.
Yeah. Any other state rules are required?
If the question arises, sir, I will share it with you.
Okay. Okay. Thank you.
Thank you very much, Dr. Vishwesh. Thank you, everybody, for
so much.
attending the webinar.
Thank
you.